in Georgia that is moving along in the ICC. So does it mean that the ICC prosecutor prioritized the case of Georgia and will brush aside the case of Ukraine, which might also explain somehow the decision of the ICC prosecutor when she narrowly focused on the interpretation of crimes against humanity. And it's also quite interesting for me that, of course, the ICC prosecutor choices are political. But the prosecutor is always saying, well, I only applied the legal test. And it's quite interesting that in the case of Maidan crimes, the prosecutor focused on the narrow definition of crimes against humanity, but did not dismiss the case on the basis of the interest of justice. And I think she was aware herself that if she were to dismiss the case on the basis of the interest of justice, that would be widely criticized. So that's why the prosecutor decided to adopt this very narrow approach. But I think there is no leeway for the ICC prosecutor not to move forward with the allegations of Ukraine with respect to the conflict in eastern Ukraine and Crimea. So I think that, I hope that we're not going to wait for 7 years, like in the case of Georgia, as we know very well that justice delayed is justice denied.
Yes, I completely agree with what Irina said, and yeah, that it's also connected. They are looking at how the situation in Ukraine is developing, and also at the case of Georgia, how this case is developing, and also you said in your presentation that they are waiting for some additional evidence in the case of Maidan, and as I know on this webpage of the OTP, they stated that the last batch of this evidence, they received it in October 2016, and yeah, probably they are doing something with it. And as I know that not only government, but rather non-governmental organizations are very active in collecting evidence and submitting this to the ICC, and not government, not that much. And I know that they collected this additional evidence. And probably it's also like shows a sign of how willing government it is to cooperate with the ICC. Probably if they were more active, the ICC maybe, who knows, would be also more willing to go into Ukraine. But now they're kind of on this very uncertain surface.
Thank you. I thank all the speakers, and let's thank you very much, and I think that now deserves our lunch. Thank you very much.
Я должен где-то в 6 буду идти.
Уши они не слышат.
Okay, we will start now. I hope we are not too late. We are missing one of the presenters, but he will come later on and fill in. But we have very limited time, so I would like to start immediately. I think that we have in front of us a very interesting panel that will be dealing with the legal remedies that are available to the victims of the armed conflict. And I just now missed the lunch reading briefly the summaries of the presentations, and basically what I have seen that the organizers very well organized the papers, and we are going from more broader perspective, and then we are tunneling to the very concrete issues in conflict related to Ukraine. And basically all of the panelists, starting from the position that we are lacking individual remedies under the international humanitarian law and international criminal law, and they are looking with hopeful eyes to the European Court of Human Rights, and they will be dealing with these issues in different ways. And I don't want to steal their time anymore, and I'm very interested in what they, as a judge of the European Court of Human Rights, very interested to see what they have to say about all of that. And we have our first speaker, Vito Todeschini, who is a fellow at Aarhus University, and he will be dealing with, the a more general approach to this problem. So, floors.
Yeah. Thank you very much. And I would like to thank the organizers for inviting me at this very, very interesting conference. So, mainly in my paper, in my discussion, I will deal with the concurrent application of international humanitarian law, so IHL, and human rights law, and specifically in the areas of the right to remedy and reparation. And my main argument, that it has been anticipated by the moderator, is that since we don't have under IHL an individual enforceable right to remedy for victims, then human rights law can weigh in and fill this gap, or what I perceive as a gap. And I will show that this is an opportunity in itself and brings about also other opportunities, but we also face challenges in this respect. And as just a preliminary note, I will deal with states' obligation to provide a remedy and the possibility for victims to have a remedy or reparation vis-a-vis a state, so Ukraine or Russia. And I don't deal with non-state actors. So, first of all, let's start from the concurrent application of IHL and human rights law from a general point of view. So the idea that human rights law continues to apply in armed conflict is well settled now, I would say, since the first pronouncements by the International Court of Justice in the nuclear weapons advisory opinion. And another point that has been well made by the ICJ but also by human rights bodies is that, to an extent, in armed conflict, human rights law needs to be interpreted in light of IHL. This will specifically concern the conduct of hostilities, and for example, one example is that the prohibition of arbitrary deprivation of liberty or life, or better, if a deprivation of liberty or life is arbitrary, will be determined in accordance with IHL and not human rights law. This is the kind of mainstream interpretation in a way. But there are some new developments, especially in the jurisprudence of human rights bodies. And first of all, or better, for the first time, these bodies are stating in express terms that while they concede that human rights law may be read down in favor of IHL, at the same time, if IHL is violated, then you also have a violation of human rights law. And this is a very important statement. And also a new development is that human rights bodies, and especially the Inter-American Court of Human Rights, the African Commission, and the Human Rights Committee, are also taking an expansive interpretation of human rights law in our conflict. For example, saying that if IHL is violated, even if no war crime is committed, anyway you can have a violation of human rights law. So, for example, if an attack poses real risk to life or fails to follow precautions that are prescribed by IHL, then you could anyway have a violation, for example, of Article 6 of the ICCPR on the right to life. And this is also an interesting development that is happening in these days. Now, the question is, what are the implications of this jurisprudence for the right to a remedy and reparation of victims? To answer, we need to first look at what IHL says in respect of individual remedies. So, in IHL, we have two important provisions in this respect. We have Article 3 of the 4th Hague Convention from 1907 and Article 91 of Additional Protocol 1. And these provisions say that if the case demands, a state has to pay compensation for violations of IHL that is responsible for. And the ICRC customary study on customary IHL says that this is now a customary norm that applies both in international and non-international armed conflict. And the point is, do this provision give individuals a right to remedy? We have mixed views on this. So we have a famous view by Fritz Karlshoven that was expressed in an article from 1991 that says that the drafters of the Hague Convention 4 actually wanted to provide victims with a right to remedy. And it says that already at that time it was envisaged that in theory a victim could try to bring a claim for damage in the responsible state's domestic court. However, courts and state practice more or less run counter this claim, because if we look at the reparation related to World War II, we see that all reparations have been dealt with at an interstate level. And also many cases in Japan, the US, and Germany, also very recent cases that are discussed like right now, for example, the one related to the incident in Afghanistan in Kunduz. Well, courts tend to deny to victims to bring a claim directly against the state in its domestic court. And they always say that IHL requires an interstate mechanism. So the conclusion could be that at the best, IHL provide a right to substantive reparation to victims, but then victims cannot go to the responsible state domestic court to try to enforce it, and they need to go via their own governments. Now, here is where human rights law comes in. As you well know, most, or I would say all, human rights treaties provide that right to remedy as a central right, because it's the way to enforce a right, to make it practical, right, not only on paper. And they provide both for procedural rights, so the right to access a court or an administrative body, and the substantive aspect that is to get redress, to get reparation for a violation. And human rights treaties impose an obligation on states to establish a remedy at domestic level. And this is very important. So, in light of what I said about the concurrent application of IHL and human rights law in armed conflict, we can note that if, as I said before, a violation of IHL entails a violation of human rights law, then it also means that victims can look for redress, can search for redress under human rights law instead of IHL. And this is very important because it can fill that gap that I identified in IHL, so the lack of individual remedies enforceable at domestic level. Now, as I mentioned, there are both opportunities in this interpretation, but also challenges. And I'm going also towards the conclusion. So, first of all, the opportunity, I just mentioned it. It's exactly the possibility for victims to get reparation for IHL violations. And this also means that this is a way to enforce IHL through human rights law. This is a big opportunity, I think. And a second opportunity comes from this expansive interpretation of human rights law that human rights bodies are tend to give now in this moment. And for example, when a human rights body says that the right to life is violated even if when a state fails to take precaution to avoid collateral damage, or if an attack endangers the human life even without like human losses, then it means that victims of, for example, an attack that doesn't comply with the principle of precaution could seek redress just because their life has been endangered. We find this kind of statement, for example, in a case from the Inter-American Court of Human Rights, that is the Santo Domingo massacre case. We find it in the draft general comments 36 of the Human Rights Committee that has not yet been adopted, or also in the most recent General Comment number 3 from the African Commission. And I think that this is a second interesting opportunity or development that we have. But as I said, there are also challenges. And I will mention just two, one of a normative nature and the other one of a practical nature. So the normative obstacle could be jurisdiction, in the sense that we know that human rights treaties applies when a state exercises jurisdiction over a territory or over a person, and especially in extraterritorial context. But for example, and this will probably be a problem within the European court system, because we know that there is this case law started with Bankovic about extraterritorial jurisdiction, in which it was denied that the European Convention could apply if during a military operation, like when you have just bombing without boots on the ground. And for example, if you take the case of the Ukrainian army shelling or bombing a location in the rebel-held areas in eastern Ukraine, where Ukraine has no control, could you say that they are exercising such jurisdiction that makes the European Convention applicable? I would say yes, but maybe the European Court could say no if we look at its jurisprudence. So for example, this could be an obstacle to the application of human rights law, and so also for victims to have remedies under the European Convention. And another obstacle, it's more of a practical nature, and it's more the question whether the individual remedies are the right means to try to seek reparation in an armed conflict. So I mean whether like state courts can really deal with potentially mass claims. This can be a practical problem that has been raised by some commentators. And so, for example, it could be the case that it is better to employ compensation commission like we had, for example, for the conflict between Iraq and Kuwait. And I mean, this is a question that I'm raising actually. I don't have really a strong view on this, but I think that is something that we need to reflect on. So this would be my conclusion, that the concurrent applicability of IHL and human rights law provides opportunities for victims of armed conflict, but still we have challenges to face and we need to analyze them and reflect on them. Thank you very much.
Thank you very much for your interesting presentation and for explaining to us opportunities, but also to presenting the challenges. And I hope that your presentation will provoke some discussion. Our next speaker is Antal Berkes, and he will speak about the settlement of concurrent applications by the European Court of Human Rights from areas outside the territorial state's effective control. So a little bit changed from what we have in our schedule. Thank you.
Thank you, Madam President. My ladies and gentlemen, I will continue the same streak of thought, supposing that the most effective legal remedies that victims from areas outside of Ukraine's effective control can seek is the European at the international level, the European Court of Human Rights mechanism. First of all reliable human rights reports reported on massive and human rights violations, and added that the domestic remedies available in Crimea and the de facto remedies in eastern Ukraine are ineffective, and all other domestic remedies from Ukrainian authorities are physically unavailable. Bearing that in mind, consequently, many thousands of applicants address their claims to the European Court of Human Rights, the most effective and maybe the only binding legal remedies available for them. The European Court of Human Rights has been already seized by 3 interstate applications Ukraine versus Russia, and more than 1,400 individual applications. While facing the difficult question of dealing with a high number of both individual and interstate pending cases concerning the same region, the court shall deal with complex factual situations also and take into account various other ongoing international mechanisms such as the ICJ, various United Nations treaty mechanisms, or even investment arbitration. The European Courts of Human Rights case law is basically has many precedents where it dealt with similar issues. If we see the statistics from Transnistria, there has been already eight resolved cases with 3 Grand Chamber judgments and 20 or 30 individual applications already communicated. From Nagorno-Karabakh, 2 Grand Chamber judgments already published and 9 communicated cases. Abkhazia, South Ossetia, no case yet decided, but 1 interstate application, the Georgia versus Russia, and more than 3,000 individual applications still ongoing. This case law and pending case law can serve as a basic example for the court for the ongoing Ukrainian cases. And what I propose in the forthcoming minutes is to think about the procedural issues, how the court could the most effectively address these cases and settle the concurring judgments, concurring cases. If we try to define concurring cases, concurrent applications are defined as applications filed with the court by individuals and by states concerning the same factual context, namely a region, a conflict region outside the territorial state's effective control, and directed against 1, 2, or even more respondent states, while analogous international ongoing dispute settlements are pending. This definition corresponds to 3 concurrent factors: concurrent procedures, concurrent applicants, and concurrent respondent states. I will address each of them in the forthcoming minutes. First of all, concurrent procedures of international investigation or settlement. Why is it a problem? It is a problem because Article 35.2.b of the Convention provides that an individual application is inadmissible where it is substantially the same as a matter that has already been examined by the court or has already been submitted to another procedure of international investigation or settlement and contains no relevant new information. Before the European Court of Human Rights, several respondent states in similar cases involved the ongoing status talks, for example, about the given disputed area outside the territorial state's effective control. But the court seemed to interpret this least pendants rule quite flexibly. In the Georgia versus Russia admissibility decision, it held that the ongoing ICJ and then already terminated ICJ is not such a least pendants because individuals have no remedy for reparation before the court, and individuals are not parties to the ICJ. In the Varnava case concerning Northern Cyprus, an internationalized committee on missing persons was considered by the court as not an effective least pendants, because in this case also the individual applications had a status but not against the same respondent states against Turkey. Or in the recent Chiragov and others versus Armenia case, the court held that the OSCE status talks are not considered as least pendants because the applicants were not parties, and this mechanism was rather a diplomatic talk rather than a judicial or quasi-judicial procedure. Having said that, if we consider the Ukrainian case, we have concurrent procedures before the ICJ, but even though Ukraine seeks to have a remedy to ask the court the ICJ to order massive reparations for victims of racial discrimination and of victims of terrorism, in the ICJ procedure, individuals are not parties, and that's why probably the the case will not make inadmissible the individual applications and not at all interfere with the interstate applications before the European Court of Human Rights, bearing in mind that article on lease pendants, the provision on lease pendants applies only to individual and not to interstate applications. There are ongoing individual communications before the United Nations Human Rights Council, but again, this is not an effective remedy where individuals have a stake in the procedure, so this won't exclude the admissibility of the pending cases. Another pending disputes concerning Crimea are the investment arbitration proceedings brought by companies owned and controlled by the Ukrainian state against Russia. In those cases, the pending investment arbitration can only, and to the extent make inadmissible the ECHR cases as long as they concern the same matters, the same right to property disputes. Beyond the identity of matters, I add that the European Court shall also take into account not only the matters, but the legal and factual conclusions of other international bodies. The cross-referencing of judgments in the legal conclusions is already the valid case law of the court. It refers extensively to the ICJ cases, especially in those cases where such conflict regions are affected. This strengthens the unity of international law and prevents fragmentation. Beyond that, even factual conclusions of other international dispute settlements will aid the court. The factual findings of international criminal tribunals are more and more cited by the court in the section background of the case. And in the cases concerning Crimea and Eastern Ukraine, especially fact-finding of international organizations, dispute settlement bodies, and NGO reports are likely to be cited. Or rather, in a concrete Malaysian Airlines case, the already published reports of the fact-finding mission in the Netherlands. Such an integrative approach assures a harmonious interpretation of the Convention. As for concurrent applicants, the major challenge that the huge backlog from the CE region raises are the timely settlement of all cases, the individual examination of the case, and also the good administration of justice, elucidating all the factual and legal complexities of the case. The court, in the precedents from such conflict regions, used, it seems to me, three major procedural techniques to allow to deal with such a massive case law from individual and interstate applications. Firstly, the joinder and simultaneous examination of applications, the pilot procedure, and the other procedures that led to principled conclusions, which and the Committee of Ministers calls judgments of principle. So first of all, the joinder or simultaneous examinations of cases. This is a procedural technique that is allowed by Article 42 of the rules of the court. The joinder allows the court to join in one common procedure individual applications. If the parties do not request the joinder, for example, because the applicants are unaware of each other, it is the registry and then the designated chamber who decides on joining the cases. My problem is that it is very outcome dependent. It supposes that the legal and factual background of the case is the same. In the Berami and Saramati cases, the court joined the cases because both two cases affected the then Kosovo under international administration. And the legal conclusions were the same. Both kinds of violation were held, attributed to the international administration, but it received many criticisms because, in fact, the attribution and the agents' attribution and the order structure within the NATO and the UNMIC was totally different, and it is likely that the court had a very bad ruling by joining the two cases and not simultaneously examining two independent cases. The simultaneous examination, said before, means that the court decides only to to conduct 2 independent examinations simultaneously in 2 procedures, but with the same formation of the chamber or grand chamber. This technique was used in the recent 2 Nagorno-Karabakh grand chamber decisions, in the Chiragov and Sargsyan cases, both related to the denial of access to homes by internally displaced persons. The 2 cases were in the legal problem similar, but the factual problem complementary, let's say symmetrical. Not identical, because the Chiragov case concerned the claim of Azerbaijani internally displaced persons from the occupied Armenian territories, whereas the Sargsyan case concerned ethnic Armenians' claims to return home to their village in Azerbaijan. So the 2 cases show 2 different facets, complementary facets of the same highly politicized frozen conflict. And my claim is that the court very well decided to examine in 2 simultaneous procedure the 2 cases. Another very useful procedure is the pilot procedure. This allows the court to suspend thousands of cases while deciding on 1 case with similar structural and legal problems. This was the case in the Xenides arrested case concerning the property compensation mechanism of IDPs from northern Cyprus. The conclusion has led to the creation of domestic remedy by the Turkish Republic of Northern Cyprus, mainly a de facto authority under the effective control of Turkey, the respondent state. And with this decision, the court assisted to the annulation of 1,400 property cases pending before it, and leading to the domestic remedy. This is also the case with the Georgian cases. There are, as I mentioned, more than 3,000 applications, and in the communicated cases, the court systematically asked the applicants whether they see any possibility to give rise to a pilot procedure, and whether there is a structural or systematic problem in other similar cases concerning the same violation of human rights. Consequently, the court should coordinate its pending cases while taking into account the possibility of pilot procedure in Crimea and eastern Ukraine. The judgments of principle, finally, the judgments of principle, this is a notion used by the Committee of Ministers. It decides, a judgment of principle decides on a generalized problem, and later cases will refer to the same conclusion. It happened in many cases, already decided cases. For example, the famous Northern Cyprus case, Lizidu. In this case, decided on the extraterritorial jurisdiction of Turkey and its responsibility and attribution rule, and the Grand Chamber cites regularly this case to decide very early on the admissibility of the cases from Northern Cyprus. Another example is the Varnava case concerning the admissibility, the time element admissibility, temporal admissibility in enforced disappearance cases. And with this conclusion, the court decides systematically also about the admissibility of similar IDP cases. So judgments of principle could be a solution for the effective settlement of concurrent applications, whereas they concern massive violations of human rights, which is the case with the Ukraine versus Russia interstate applications, where an interstate application concerns not massive violations of human rights, but one individual application. Ideally, if there is a pending concurrent individual application, the interstate case will be withdrawn, which happened with the third Ukraine versus Russia case, which concerned one individual, Zemilov versus Russia, which was also a pending case before the court concerning an Ukrainian national belonging to the Crimean Tatar ethnicity. and in this case the interstate application was withdrawn. So briefly, the above mentioned procedural techniques will allow the court to enforce its good administration, coordinate the settlement of cases filed by a variety of applicants, and the choice of combination of the given procedural techniques is dependent on the factual and legal background of the pending applications. The very final point, concurrent respondent states, I just refer to the already established Transnistrian case law. In such cases, the victims can address their claims against more than one respondent state, and the court will determine the responsibility of each of the respondent states and engage with dual or multiple responsibility of states. The Russian Federation was held responsible in the Transnistrian cases for the same violations as complained by the applicants against Moldova. Moldova's responsibility was engaged on the basis of the failure of its positive obligations vis-à-vis persons present in its sovereign areas but out of its effective control, whereas the Russian Federation incurred responsibility for its attributing the de facto authorities' violations to it. Since the Ilashku judgment, the same procedural strategy and litigation strategy against two co-respondent states was used by the applicants in the Transnistrian cases, and also recently by the Güzeli-Örtlü case against Cyprus and Turkey. In this case, this case was about the procedural investigation obligations of both Turkey and Cyprus concerning the abduction of 8 Northern Cyprus individuals from Northern Cyprus to the Green Line between Northern Cyprus and the Republic of Cyprus. And the case, the court again relied on the simultaneous due diligence obligations of both states. Furthermore, the concurrent jurisdiction might be even multiplied if we add a third state. For example, some pending applications from Transnistria rely on a third jurisdiction, namely whenever there is an Ukrainian national, they rely on Ukraine's responsibility for human rights violations occurred in Transnistria, namely arguing that the state of nationality has similar due diligence obligations as the state of the territorial state Moldova. There is no precedent for that. I'm doubting whether it will lead to any third jurisdiction. I don't think so, because it, at least in diplomatic protection cases, that was never the case, but at least it shows that the multiple jurisdiction could be a procedural strategy, both for the court and both for litigants. So, for conclusion, while deciding on individual circumstances of cases, the court should rely on the legal and factual conclusions of other investigation and dispute settlement bodies and coordinate its conclusion with regard to concurrent litigations. The pending interstate cases should serve as the first major judgments, let's say judgments of principle, to address general problems such as jurisdiction ratione loci, ratione personae, victim status, or the availability and effectiveness of domestic remedies in de facto regimes like Eastern Ukraine. Facing concurrent respondent states, the court should continue to rely on general international law and recognize the concurrent state responsibility. In sum, the court's coordinator function is settling thousands of pending applications from Crimea and Eastern Ukraine, ensures the coherence of the case law and the effectiveness of the convention. Thank you very much for your attention.
Thank you very much. It's always interesting to see from the outside how we are seen and how we can be better, or how we are doing well certain things. And now we have our third speaker, Tatiana Ansupova. And now we will come closer to what is happening in Ukraine and to the possibilities of the remedies. And she will explore the issue of the restitution of property, and possibility.
Thank you. Let me start
by expressing my gratitude to the organizers of this conference. And it's an honor for me to be a member of European Society of International Law and participant of such an interesting event. And also I thank our moderator. Thank you very much. Turning to my speech, to my presentation, I will start by saying that for transitional justice scholars, the term reparations tends to be used in two contexts. First, reparations under international law, measures to redress harm as a consequence of certain violations of international law, including international criminal law. And secondly, reparations programs under domestic legislation, coordinated sets of preventive measures with extensive coverage. I'll talk today about the national level remedies in the context of the implementation of international law, and first of all, the approaches of the European Court of Human Rights and partly the Parliamentary Assembly of the Council of Europe. And I'll concentrate on individual property rights. Referring to the basics of international law, in this sphere, let me remind you that according to UN principles of housing and property restitution for refugees or displaced persons, the binary principles, principle 2 and 21, compensation is an integral component of the restitution process. 3 years ago, Ukraine joined the ranks of the conflict zones in Europe, and according to the Ministry of Social Policy figures, as of 25 of April this year, there are around 1.6 million persons are currently registered as internally displaced in Ukraine. And almost 2,000, let me correct you, my colleague, 2,000 individual applications related to the events in Crimea or the hostilities in eastern Ukraine are pending before the European Court of Human Rights, as well as 5 interstate applications. Particularly, such individual applications include a wave of complaints about property losses against the Russian Federation and Ukraine, or Russian Federation or Ukraine. Regrettably, lacking an effective national remedy, owners of damaged or destroyed property have turned to the relief to international judicial bodies. Indeed, during last 3 years, Ukrainian authorities do not rush, so to speak, to create an effective systemic approach of national restitution remedies for property. And the first budding hope, so to speak, that Ukrainian authorities will pay appropriate attention to the problems faced by displaced persons appeared with the adoption of a national human rights strategy. As you know, it was adopted in 2015. Moreover, the action plan on the implementation of such a strategy until 2020 also has been adopted by the government. And some provisions of this action plan are the follows. Formation of a working group to develop the procedure of compensation for property that was damaged as a result of anti-terrorist operation, and development of a draft legal act based on the analysis conducted by a working group. Indeed, more than 1 year ago, such a working group was created. At the same time, the legal act regarding the procedure of compensation for the value of the damaged property is still under consideration of the parliament, in the parliament. Initially, 4 such different draft laws were proposed, and per now, 2 of them were rejected and withdrawn from consideration. Talking about other 2 draft laws, first of them, it is draft law number 3434 on amendments to the law of Ukraine on combating terrorism concerning compensation for housing damaged as a result of an anti-terrorist operation. So it's law on amending other law. Let it call draft law 1.
This draft law provides for compensation for damages only for damaged or destroyed housing. It covers damages caused by terrorist acts as well as damages caused by the security operation. However, it doesn't establish the mechanism for obtaining that compensation. Instead, it stipulates that the mechanism is to be established by the government of Ukraine. Talking about the second draft law, the draft law on compensation, so it's separate draft law on compensation of damages caused by a terrorist act. It goes through the parliament. We can observe that it goes through the parliament procedures quicker than the first one. And under this draft law, applicants, that means an owner or his/her representative, all residents, not only citizens, may apply. So they will apply for compensation to the regional state administrations. The applications will be reviewed by a special commission which will assess the damages and decide on compensation within 45 days. And it's important point that the Commission's decision can be challenged in an administrative court. Both of these draft laws have been criticized a lot, and summing up the analysis of above-mentioned draft laws and current accessible legal instruments in this respect, we should acknowledge, first point, the significant challenge of establishing the actual extent of the damages for the residents in the Donetsk and Lugansk regions. A special commission which would assess the damages and decide on compensation will not have access to the property located in the territories which are not under control of the government of Ukraine. At the same time, the question is if, and my colleague already referred to this question, if Ukraine still has positive obligations under Article 1, Protocol 1 to the Convention for the Protection of Human Rights, which was not derogated from. Ukraine was not derogated from this article of the Convention. In order for national remedies to be effective, it's necessary to enable the local commissions to assess the damages in the territories beyond the control of the Ukrainian authorities. Obviously, it's hard to realize, but maybe we should try. As in one of the publications of Judge Yutkivska, I found an example, really a landmark case, landmark judgment in the case of Ilashko against Moldova in Russia. Namely, for the first time, the court found that a state which doesn't have an effective control over a part of its territory as a result of occupation by an unlawful separatist regime and is unable to exercise its jurisdiction there, still has some positive obligations deriving from the de jure jurisdiction. However, careful reading of the Ilashko judgment shows that the paradox lies in the fact that the Moldovan authorities, by a kind attitude of cooperation towards the separatist regime, triggered their positive obligations under the convention. The second point, that until present time, there is only one legal provision which is in force within the Ukrainian legislation, which regulates compensation for the damages caused by a terrorist act to the citizens of Ukraine. It is in Article 19 of the Law of Combating Terrorism, adopted by the Parliament of Ukraine in 2003, long time ago before the conflict has begun. This article stipulates that the compensation for damages caused by a terrorist act to the citizens must be financed from the state budget. Thus, only citizens of Ukraine, not other residents, in case they would apply to the court to apply the traditional justice and will prove the facts of ownership of the property which were destroyed, can hope for the decision in their favor under Article 19, and we know that several cases have been already examined in this way. But we're talking only about citizens of Ukraine. Thus, this instrument cannot be considered as an exhaustive one. Moreover, one more reason for criticism at the governmental level of this norm, including it relates also to the draft law number 2, as I said before, is that compensation must be financed from the state budget. But it's known that the expenditure part of the state budget for this year and previous 2 years, there's no any special provisions on certain amount allocated for compensation for such damages. Looking ahead and referring to the case law of the European Court of Human Rights, in the case of Suk against Ukraine, 2011, the court has not accepted the government's budgetary argument, as it is not open to a state authority to suit a lack of funds as an excuse for non-honoring its obligations. In this case, in case Suk against Ukraine, the court has found the violation of Article 1, Protocol 1 to the Convention. Point number 3. The current state policy of decentralization in the context of our topic means that, according to current legislation, costs for temporary accommodation of IDPs, in this year particularly, will be funded from the local budgets. In this respect, the UN Human Rights Monitoring Mission, in its last report, 17th report, underlined that lack of access to adequate housing has a direct impact on displacement patterns and returns to the conflict-affected area. 70% of IDPs who permanently return to the conflict-affected area do so to protect their property, and 22% because they could not afford rent. This illustrates the consequences of the lack of concentrated steps by the government to ensure durable housing solutions and successful integration, and inability maybe partly to cover this issue from local budgets. Using the terminology of the European Court of Human Rights, that also may mean that the state may put an excessive and disproportionate burden on IDPs because they couldn't afford rent. Fourth point, it may be worth noting that in December 2015, the Comprehensive State Program on Support, Social Adaptation and Reintegration of Citizens of Ukraine who moved from the temporary occupied territory of Ukrainian areas of counter-terrorist operations into other regions of Ukraine for the period until 2017 has been adopted. It follows from the last month's report of the Minister of Social Policy on implementation of this program that, according to the information of Donetsk and Lugansk regional state administrations, the number of damaged housing facilities requiring priority attention are 61 in Donetsk region and around 7,000 in Lugansk region. It's also worth mentioning that Ukrainian authorities seek different ways to facilitate the implementation of government housing programs, particularly by amending the law of preventing the impact of the global financial crisis on the construction industry and housing, and providing some benefits for IDPs, but also it's like separate projects of the government, not a systemic one. At present, we can observe that different national instruments work for IDPs and for persons who still live in the conflict zone. Moreover, different instruments work if the victims apply to the court or to the civil military administration in eastern Ukraine or other local authorities if they are citizens or other residents, not citizens. And finally, there is totally different situation for the territories beyond and under control of Ukrainian authorities. It's known that hundreds of times the European Court of Human Rights dealt with the post-conflict issue of property of displaced persons. However, it's impossible, I think, to find a complete coincidence of situations and to be sure beforehand of what conclusions and what findings the court will come in cases against Ukraine and Russian Federation related to conflict in eastern part of Ukraine. Last year, in October, in 2016, the Parliamentary Assembly of the Council of Europe has adopted a clear position reflected in its resolution 2133. The DPR and LPR, established, supported, and effectively controlled by the Russian Federation, are not legitimate under Ukrainian or international law. This applies to all their institutions, including the courts established by the de facto authorities. Under international law, the Russian Federation, which exercises de facto control over the territories, is responsible for the protection of their populations. Russia must therefore guarantee the human rights of all inhabitants of Crimea and the DPR and LPR. It remains to be seen whether the European Court of Human Rights will follow the same reasoning. But notwithstanding any position in this issue, Ukraine is not precluded from establishing a property claims mechanism allowing the applicants and others in their situation to have their property rights restored. Once again, referring to the principle of subsidiarity, the primary obligation of reparation for violations of an applicant's rights under Article 1, Protocol 1 is to be found at the national level. Obviously, lack of access to adequate housing and absence of national mechanism of compensation for damaged property may open a Pandora box, or in other words, will lead to one more systemic problem within the national legal system of Ukraine. And at last, my very final conclusion will be the following. All of us should understand that Ukrainian stakeholders adopt not easy decisions during ongoing conflict. But I think it's time already to make the steps in respect of mechanism of compensation for the damaged property if we don't want negative consequences. And maybe it's would be a very positive step to ratify at last Protocol 16, because it's signed already, and for new created courts, because we have a judiciary reform now, to apply to European Court of Human Rights for advisory opinion, for example, and to use any other instruments and mechanism to create it systemically. Thank you for your attention.
Thank you very much. And now we are turning to our last speaker. We have a little bit, a little change. We will have Max Petrov, who will speak to us, and he's coming from the very same institution. This is Helsinki Human Rights University, is it?
Union.
Mm-hmm. Mm-hmm. And he will speak about national mechanisms as well, if I have, and remedies, if I have understood.
Thank you. Taking in consideration that previous speakers and my colleagues already told a lot about almost the same topics. I'll try to be shorter, just not to take your attention to the things which were already discussed or just put to your attention. So I would like to propose you such a topic like reparations for damage caused by the armed conflict in the east of Ukraine. Here I propose some kind of statistics just for your imagination. What is, let's say, at least the official situation in Ukraine. So we can see that according to the statistics provided by the Office of the United Nations High Commissioner for Human Rights, there were fixed 32,000 of victims, including civilian, military people, and so on. I think it's pretty much the other situation which we can see on the screen is that this crisis, this armed conflict on the eastern part of Ukraine causes a large amount of migration movements, and there was there were almost 1.6 million displaced persons, but could you imagine? It's 1.3 families. It's just very much. Children, elder people, that's a very uncomfortable situation. And if we speak about the caused material damage, we should say that losses from the destruction of infrastructure during the period of 2015-2016 cost like about 470 till 15 billion US dollars. So that's a large amount of money. And also we can say that our organization, Ukrainian Helsinki Human Rights Union, made an investigation which showed that very often our official bodies like don't really care about the protection of usual people, and when they I mean the representatives of our military different services, security service, for example, communicate with those who came from the east of Ukraine, they mostly speak about the amount of arms, amount of weapon which is controlled by terrorists, but not about the violations of human rights, not about the situation with the children, not about the social problem, just about the weapon. That's what's the most interesting for them. So here I underlined what could be most common violation regarding national and international humanitarian law. So there are non-numerous observance by the parties involved in the conflict of immunity of civilian sites. Often the attacks made on military objects cause damages, very serious damages to some humanitarian objects. And of course, very common case is kidnapping, robbery, seizure of property. And this is a very usual situation, like looting, maybe even the executive, the situation that executive authorities often make decisions that violate the right to peaceful enjoyment of property. So these cases are met very often in Ukraine, and unfortunately there is not like stable practice of resolving of those situations. In such case, what would we think, what would we do just to fix the situation? What would we propose? First of all, we would like, it's like logical, but still, there are no dialogue between the government bodies, between the state and between non-governmental organizations, and especially victims of that anti-terrorist situation, operation. Sorry. So there is need to start hearing each other at least at last. The second step, which we would like to propose, is the need to simply determine the capacity of the judicial power to reparations by reviewing those cases or decisions which were already accepted, and then maybe suggest what was not really correct and how it can be fixed. And like it says, in the case of obvious inability, just to establish what should be the different, what should be done just to resolve the problem. And the fundamental positions should be a basis of the development out of court reparation programs, meaning that there's not the only one way to resolve the problems, not necessarily the court, actually. And of course, there is a need to consult international experience, international organizations, about their assistance in resolving problems which very often are similar to the situations which happened in other countries on international level, maybe. So I finished. Thank you for the attention.
Thank you very much. So we had the opportunity to hear four presentations that were dealing basically with more or less the same issue, and this is the remedies. And then the remedies, we actually concentrated on the remedies that are related to the property issues at the end, and right to compensation or right to restitution, or even the right to go back and to acquire your own property that has been taken by the war. I'm coming from Croatia. We are facing these issues, and we were not able completely to resolve these issues, although already 20 years have passed. The cases that are coming, I have heard cases that have been mentioned, cases that are related to Cyprus, or cases that are related to Transnistria, or basically in terms of the property. Yes, we had Cyprus cases, and we had Azerbaijan and Armenian case. Moldovan cases are not related basically to this issue, as far as I know. Georgian cases are related to different issues. The problem in Croatia, for example, cases coming from former Yugoslavia have their specificity because the war took place before Croatia or before the states of former Yugoslavia became members of the convention. So we have this temporal issue there, and we could not look into the substantive issues. We could look into the procedural issues, and then in terms of the property, it is a problem. I'm actually, as a national judge, waiting for the appropriate case to come, and we are not getting the appropriate case. And I will just give you the example so that you understand how we dealt with that at the domestic level. We also have the law that is related to the terrorist activities, and then we have the law on the compensation for the damages that were caused during the war. So that there are these two different laws, and you could see how the state was unwilling, actually, really to deal with the issues of compensation, because the compensation was related to the finding by the court that the war crime actually was committed. So that is, and you know, you have so little cases at the domestic level where there were but a relatively little number of cases where the actual perpetrator has been identified. And this is not really the right way to deal with those cases, you know? So only the people that really got the judgment at the international and domestic level can claim damages, victims can claim damages, other victims are actually not getting the compensation. So it would be really interesting, you know, to see how the court would deal with that issue if that issue would come. Why this issue is not coming? Because the statute of limitation to apply is quite short in Croatia, you know, to apply in front of the domestic